group is still active and proposes discussion of several subjects that we're going to be discussing today. The Brazilian General Data Protection Law was edited and published in 2018 and was inspired by the GDPR, the European law. And this law brings a new paradigm to information management by companies and individuals in the country. And this is transforming all activities deeply, and extrajudicial services are included. Notaries and registrars are mentioned in Article 23, paragraph 4 of the law. They're also subject to the rules. The challenges are vast. There are many issues to solve. There's a highly level of information on one side and the system on the other side. The register publicity of the article and the privacy granted by law by means of several mechanisms. The notary publics, on the other hand, have a hybrid system. One part is private, which is related to the management of notary publics and by the delegatee, and a part is a public service, which is different, has a different purpose in regarding data treatment and processing related to the legatee. We're going to be discussing many other subjects, so I'm really happy to have great international authorities and who make the difference in the debate of data protection in land registries abroad, and also national authorities who are equally relevant in the debate we're going to be discussing today. I'd like to thank immensely the presence of Dr. Anna BERLEE, who is the Senior Counselor of the Holland Authority of Data Protection, Fellow at the Real Right Law of the University of Cambridge, and Masters in Private Data by the University of Maastricht. She wrote a paper which is the object of many studies here in Brazil because it's specifically focusing on the regulation of data protection versus registry publicity in Europe. She'll be speaking about the reality of Germany and Netherlands and England. We also have Dr. JUÉS NICOLAS ALVAREZ, licensing in industrial engineering by the Universidad Pontifica de Comillas and law by U.C.M. He's a land registrar since 2010 and been assigned for the registries of Lérida, Vielha, Blaguer and Torrepacheco, which is his current office. He's vocal of institutional relations of Decanato de Murcia, and also member of the Professional Registrar Association in Spain. The Spanish system is very similar to the Brazilian system, so his contributions will be equally relevant, including the solutions that they adopted in Spain, and also the actuation of the association in the self-regulated regulation. Madalena Teixeira, she's the keeper of register, a permanent member of the Consultative Council in Portugal. She's president of the General Assembly of the Center of Studies of Notaries and Registrars of the Law School of the University of Coimbra. We're really happy to have her here as well. Dr. Marcelo Rodrigues is a chief judge of the Court of Law of Minas Gerais, great author of registers and about notary law and data protection. It's also participated in several studies regarding the LGPD and notaries, and we are honored with your presence. Dr. Fernando Tasso is a judge of the Court of Law of São Paulo, coordinator of the organ in charge of personal data processing, integrates the GT of the National Council of Justice regarding LGPD. Dr. Iverja Copete is a land registrar in São Paulo, coordinator of Uniregistral IRIB and RDI IRIB, also integrates the work group of the National Council of Justice regarding LGPD and notary services and register services. We also are very honored to have the presence of these two gentlemen who are very well known and who know a lot about the subject and will be helping us a lot. We have the support and of IRIB, Brazilian Land Registry, and ENNOR, and the Council National CNR as well. So we're going to start our debate with our illustrious Professor Madalena, who's going to talk about the reality in Portugal. You can ask your questions on the YouTube chat, and the second block will have the debates. So the first block, we're going to have the presentations of our international speakers, and the second block, our illustrious debaters will do some provocations to bring light to the discussion and also answer the questions by the public. We'd like to thank again immensely the participation of all of you. We have a very busy agenda. We are really happy to have this event and IBRADIM to follow its social function to find new solutions for these issues that are related to us all. So, Dr. Madalena, welcome. The floor is yours now. Good morning, everyone. First of all, I'd like to thank the invitation. It's an honor to participate of this event. Also, I'd like to make my compliments to all our colleagues, debaters and speakers, everyone who is watching by means of the channels that are available. I'm going to try to share my screen. Let's see if this is going to work. Can you see? You can see my screen, right? So they asked me to talk about data protection regarding land registry in Portugal. So my presentation is related exclusively to the Portuguese system regarding data protection, and it's applicable in the country. So this framing during my presentation, I'd like to start to talk about a little bit of some specificities of the registry system in Portugal. It's a little bit different from the Brazilian and Spanish systems, at least regarding data protection, personal data protection. So the first thing that I would like to say is the public nature of the registry services and the ownership of the databases. Registrars in Portugal are public employees, and they have a hierarchy with the Ministry of Justice and are integrated in the public management machine. It's important that there in the Portuguese system there's no standard, and it no longer exists because there's an electronic system for land registry that includes the whole flow of tasks: production, organization, archiving, and protection of information regarding land registries. Currently, this information is materialized and aggregated in databases that belong to the Ministry of Justice and that support decentralized access from the several register services. There's the fact that the information is aggregated in an electronic environment, created a potential of production and circulation of transformation that makes it valuable for several purposes. So there's a higher risk of the use of this information for abusive purposes or incompatible purposes, those determined. and also a need for harder control in terms of personal data protection. It's important to look at the information. You're looking to the looking glass of law and regarding data protection. So we need to think that this is a fundamental right from the both from the perspective, personal and private perspectives. It's important that it integrates the structures of the state and the society, grants the owner the ability to require full exercise of its rights, and places the state in the obligation of ensuring this right. And therefore, we have the applicable rules and principles. As you know, Portugal is part of the European Union, so it's the first legislative source, and the first regulation is the GDPR, and that's where we look at for personal data protection. But there are a few clauses that are open, and currently we have the body of the regulation, but they have some, if you have some margin for confirmation for the rights, and this margin in Portugal was filled in by law 58 from 2019, and this legislative sources that regulate the law, on the other hand, they have rules regarding personal data protection, which are included in the land registries. We have specific laws for personal data protection incorporated in the land registry code. The land registry code has the advantage to count on these rules, and these rules exist since 1995. They are not resulting from the regulation, and they are interpreted in light of the rules and principles of the regulation. And that's in this environment of the discussion of these specific rules and other public entities. That's the environment that we have the regime of personal data protection in the scope of land registry. I would also say that we have a lot of normative resources, but no protection is granted effectively if we don't know exactly what do we want to protect. So that's where importance when we talk about personal data. We have all aspects related to the person, natural persons, physical characteristics, medical records, profession, and academic, but also cultural, social, and economic information that may be used as a reference for identification. So the registration of lands here, we have the description of the property, of the real estate, and we have some objective data. But however, as of this registration allow knowing the owner of the land, this registration becomes, from the point of view of the result, information that is related to one or more natural persons, and then can be considered as personal data. Another definition that we need to consolidate is processing of personal data. Regarding the processing of personal data, also the organization, conservation, and disclosure of this data, it tends to have all the compliance efforts without losing sight that the data do not go from the legal sphere to the registrar's legal sphere. the data remains belonging to the natural persons. So I used to say that there are still maximum statements that first, the data belong to the people. The data processing must be conceived to serve the people, and personal data protection is not an absolute right, and therefore there must be a balancing with agreement with other fundamental rights. So how does this uh, is, is in practice by means of the principles that are included in the General Data Protection Regulation. The Article 5 of the regulation has a very wide catalog, but I say the basic principles, I would say the purpose, data minimization and proportion and responsibility. This principle is a fundament to affirm that the right to data protection is not an obscure right and is in a fundamental right that must be equivalent to other rights. So with these principles, we have the principle of responsibility, which is maybe the one that better defines the practical objectives of the regulation. Not only have to follow these principles, but also we have the right to comply and confirm this compliance. So how does this work? How can we ensure compliance with the rules included in the GDPR? This is done by means of the adoption of technical measures and organizational measures required to comply with these rules and principles since the root, that is, since the moment of concession or definition of the treatment up to the moment of the concretization of the regulation. The regulation kind of provide a technological neutrality and doesn't go into detail of the specifications about the measures adopted. But what it's intended is that the systems to process the data can be conceived and designed to protect more effectively the rights of the owners of such data. The regulation has technical and organizational measures that include quantity of data collected, a term for conservation, and also strictly required by the purpose for such collection of such data. So we can join a principle that is not written, but it's equally important, that says about need to have awareness and awareness of the personal data protection and in the legal regime. So I'd like to say the privacy has a very attractive force, so it's used in Portuguese without any dogmatic rigor. So privacy by design, privacy by default. But although this terminology, data protections, does not confuse with privacy, and it's consisting at least at the European level. So the right to personal data protection is an autonomous right. It has its roots in privacy law, but it can be confused with such privacy law. So the regular normative, there's time to say this in land register specific. The most important thing is that register also is always related to personal data. So conserve, disclose, and transmit information that includes personal data. So the personal data protection shall not be confused with privacy, and the object of register publicity does not interfere with the right to privacy, at least if we consider that the right to privacy is related to the intimate life of persons, private life of people, which are considered intimate or confidential. But the legal facts related to the registry are legal facts of a private life that have nothing to do with this intimacy. And these external facts that these facts produce are related to maybe of knowledgeable to third parties. I'm just talking about land registries. We're not talking about civil registries, so which we could do other considerations. Therefore, I would say that land registry, only the effective knowledge of this data, we can provide legal security, static, and also security to the commerce of real estate. And therefore, we need to say publicly that the subjects of such rights must indicate their identification documents. And what is the data that is important to collect considering this objective? So, in the basic principles, we have the principle of minimization of data, and the processing must be appropriate and limited to what is required. And the criteria is quantitative, is the number of data that's important. The criteria is qualitative. The data to be processed is that is only those data, a few or many, that are required to have this registry as determined by the collection. So who does this protection? In Portugal, it's the land registry that says which personal data that must be collected and processed. Some of this data, especially those related to the people who formulate the request for the registry, and shall only be used for accounting and organizational purposes of the applicant's profile, and also the data related to the legal subjects related. And this may be disclosed freely because our legal rules says that formal publicity is absolute. So the information is owned by public services, and this information in principle is covered by the principle of open administration or principle of open file, which is included in our constitution. Article 268 of the Portuguese constitution says that every citizen have the right to know the public registries, and the rule is not required to enunciate to access such information. As part of the registry information consists of personal data, we have to harmonize this principle with the rule of the regulation. But Article 86 of the regulation says that public access to documents, although there's a possibility of intensification, is property of the member states or the union, according to the nature of the public agency involved. So this densification we have the land registry. The Article 104 says that the information can be accessed by anyone who who must know the legal condition of the building. There's no need for the applicant to have any specific condition to access this information. So this is access freedom, but I would say that this is not excessive freedom if you think that any indication to this information does not prevent abusive use and also diversion of this purpose. So this does not signify a possibility of using absolutely this information. Anyone can know this information, anyone can access this information, but they can only do it for the specific purpose of the collection, which is the legal situation of the building or specific legal fundaments that allow the deviation from this purpose. So this does not mean that we're going to have additional safeguards. These safeguards exist, and the first of them says that it's the impossibility is an essential point. So you cannot collect data based on the personal files. So and so it's different if you search information from subject A or subject B. So the information should be about the building, not about the people. So excessive access to information can be obtained by means of the registration number. If you know this number or the data related to the building, you cannot access any information from the person. So the land registry is not a center of information anymore related to personal data or real estate data. And the legal situation and any exception to this rule must be based on the law and must be based on 3 public fundaments. And what we have here with all that, this is not a sign and a manifestation of the principle of limitation of purpose, and also related to the GDPR. So the principle of the principle of purpose is essential for the personal data protection, but I say that this is also the key for this articulation between land registry and the right to personal data protection. So the Portuguese land registry law defines the purpose of such databases of the land registry, and this indication is made in the building code since 1995 and sequence of the communitary directive, and the segment is really clear about data processing regarding the limit and the impossibility of using this data for other purposes that are incompatible with the determining purpose for the collection of such data. So it's difficult to understand what is this incompatibility. It's not only invoking the public nature of the entities involved. In the regulation, we have it's essential to consider the relation between the final and later purpose of collecting such data, and especially the expectations of the owner of such data in the scope of its use. Although we have the difficulty, the test of interest must be done, and this test is the person responsible for processing the data is responsible for this test. But the processing of this data for that land registry purposes is exercise of uh, functions of public interest. And in this circumstance, instead of being responsible for the data processing, to do this a test of compatibility, to define the tasks and purpose for which further data processing shall be compatible or unlawful. At the same time, in land registry, the internal law says in which conditions we should have further processing of the data for different purposes. Uh, so first of all, we have the law that discusses the general regulation that says that based on the public interest, there may be different purposes, and also under protocols. And these protocols are subject to previous consultation with data protection entities. And therefore, there's another reason to say that you cannot invoke this public interest to immediately have access to the information, either by communication, by interconnection of data. After that, we have the list of public interests that allow access to the databases and land registries. Regarding data communication, it's limited to public entities. Direct access is to entities who are related to safety, security, and fighting crime. And you also have some resolutions that allow direct access in specific scopes, which allow access to these databases to obtain information of the assets and the location. This is also object of some consideration, specific consideration, and also must be dealt by the Commission, the Data Protection Commission, and must have the agreement between the rights of the within all regulations. So for further processing, for public interest purposes, the regulation is with this compatibility of further processing within some precautions. The regulation follows the regulation and requires safeguards for the minimization of data. This restates for the purpose of scientific investigation or for statistic purposes. This information cannot be identifiable. So we see that the data included in the land registry database can be transmitted for purpose of public interest or utility by means of specific safeguards. So, and for private interest, can we have access to this information? We know that the information collected in registrar has always been interest of the market and industry of information. And we know that the use of technology, of information technology, of database, so should be legally possible to optimize and to treat them as assets, and how to maintain use them to create other information products. So is it possible to have commercial exploitation of registry information by sharing with private entities who have exclusive private interests? And my answers is negative, not only for the case of Portuguese. In our land registry, our information is used in only the public environment, and the share with private entities for private interests violates the principle of purpose. So I'm not saying that there can be a genuine will to genuine use of such information in further processing. So within these limits, in case of registry information, these deviations should be always based on public interest and must be have a legal foundation that is specific. And the registry law is insensitive to the commercialization of such information. It's just and this legal fundament, and that is where we have the limit conditions to access this information. There's no pretension, no economic interest, no to have the information of a person with no interest. Some of this information goes to the building code. The right to personal data protection constitutes a right of all and should be in all environments for the purpose that this information can offer. In the Portuguese system, this right has compliance and is shared by all legal entities that participate in this registry activities. They all have to respond for this data and to the control authority, and they all have a purpose. The Ministry of Justice, as a legal entity, has the competence to assign the data protection officer in case of public entities. The data protection officer, they have a function to allow to enforce compliance with the regulation and in implementation of informatic computerized systems to apply the data protection principles efficiently and allow the confidentiality and safe security of this data. And the IRN is responsible for treating data. They have to enforce the law and direct access to databases. The registrar has to do the fine adjustment of the equipment used, to see the security breaches, but the registrar also is the most substantive part, which is to decide between the right to inform and the right to not inform such data. And therefore, they have to see any deviations with the rules and principles of personal data protection and enable knowledge which use land registry information for commercial purposes with reference to people instead of reference to the buildings. And finally, must educate themselves for personal data protection and to comply with the rules and principles in the regulation. I think I have exceeded my time here. I'm really sorry. I would just like to conclude by saying that land registry is always has the key for personal data protection, but we must develop this function inside the scope, which is inform the legal situation of the buildings, considering the security of a legal real estate commerce. The key is not degrade the information and therefore preserve the right to personal data protection. It's never enough to affirm state that the data belong to the people and not those who collect this data. I'm sorry I exceeded my time here. Thank you. Congratulations, Dr. Magdalena. It was excellent exposition, bringing us a lot of knowledge and a paradigm that is very similar to our here in Brazil. Certainly, there are many issues to be debated, and I would like to thank you very, very much. And now we're going to have the second presentation. We're happy to receive Dr. Jesus JUÉS. Please be welcome now. Just reminding all of you, there's a little delay uh, for the English and Spanish translations if you're home. So please, maybe we shall have a delay of 3 seconds, few seconds for the translations to do their work. Thank you, Dr. Jesus.
First of all, thank you so much, Leonardo, for organizing the seminar and invited me to participate so I can explain how data protection and register works in Spain. Let me see if I can convey how it works from here. My slides are here. And I have this topic. It's an introduction, the framework, and we are going to compare the Spanish and the Brazilian framework. And the fundamental aspect of this exposition is the intervention and the role of the register in Spain for protection of data, personal data, and then in the end, we are going to see the benefits that I do believe that we have when we implement the GDPR, especially England registers, and the real estate treatment. The fundamental I would like to see, and in Spain, and in all the countries that we have land register, the objective is very similar, legal safety to this real estate process, sales, purchase, mortgages, also public management, so they know who the landowners are in case of that. It's easy to access their goods. As a consequence, the advantages that we have in the land registry and the landowner, the person who is inscribed as the owner of the land, that are political effects in our legislation, very powerful ones. That is also a counterpoint. The first, you have to provide some information in order to access this public register. As a consequence of the data administration, that is, the register of the property is a very powerful database. And here we face the first problem, the first conflict of interest. How can we find a balance between the public characteristic of this register and the protection that is necessary of personal data that we have of the people there? I will try to explain in these few minutes that I have what is the system that we are going to organize in Spain. First of all, as the framework, Spain and Brazil. In Brazil, there are two fundamental legislations. The first is the Article 17 of the Public Register from 1973 that states that any person can require a public register and information without explaining the reason or the interest of your application. But in the current legislation, we see that the GDPR has been approved, establishing guarantees for the personal data and also measures that in the great majority, as Bernardo said in the introductions, were inspired in the European legislation that has more legal and juridical tradition. That's the direct application. That's where we are. A possible conflict of interest between the legislation in 73 and 2018, because it seems that we have greater importance to free access of data. And on the other hand, 2010, this legislation establishes safeguards and protections to all the data that are inserted in the registers, and also their information. How can we solve, and what is the regulation in Spain? In Spain, we have, first of all, sectorial legislation, and on top of that, we have a general legislation. The specific legislation of direct application in all the registers of property, we have the mortgage law that treats directly the publicity in registrations. And all this topic is developed also in the mortgage legislation that talk about the register and the publicity of the information. Norm, as in general, we have 2016 about the treatment of data person, and the circulation of data in Spain has been developed in an organic law, 2018, the protection of personal data and ensure of the rights, replacing the organic law that we had in 1992. So what is the compatibility of the legislation in practical terms? The legislation establishes in Article 2.3 that for some procedures, we have to see, first of all, the legislation for data protection according to specific legislation, if applicable. No, if it does not regulate, you can the provision of the organic law and the aforementioned regulation. So the provision mentions specifically the application directly of the sectorial normative in the civil registered property and mercantile registers in Spain. So in this, most of the legislation and the reference that I have in this presentation, they concern to the Law and Mortgage Act, because it's very complex, this legislation on data protection, and it was already developed before the approval of 2018 legislation, because data protection has always been in the real estate system in Spain in a high interest and in a high protection. That is a special regulation because of the great consequences that it have. Good treatment of data protection and also the bad treatment of this data. So as a consequence, the sectorial legislation, this specific legislation we have, first, I liked, and I would like to introduce this for you in this presentation, the reasons of Decree 1998 that has brought changes in the Mortgage Act, talking about the formal publicity of property registers, referring specifically of the register, the person in charge in Spain for data protection, the personal data in the register. There is no publicity without a professional control of a register. As a general rule, we see in the 2022.6 Mortgage Act, so the registers, when classifying the content of the register entries, shall inform and ensure compliance with the applicable rules on the protection of personal data. So based on these two articles, we see the role, the leading play of the registers of properties in Spain to protect personal data. So these interventions of the registers, the officer, there are two fundamental moments. First, as the first phase, I will call it, is the processing of data that goes to the register system. The registers must qualify all this information, incoming information. What is really the important one that has juridical legislation and goes to the register of property, and which one does not have juridical transaction, has to be outside this registration. And in this moment, once this data is part of registration, they determine how the publicity is going to be, which data is going to be public and how. So before going on with the registrator, I would like to say two things. As Madalena commented before me, the registrars in Spain, they are public workers. They are not people in the private section. They have a specific system and in their regulation, but they are public workers. The clear example that we have, in order to access a register of piece of property, you need to attend university and you have to go to a public examination in order to apply for these positions. So, also is the direct responsible person to treat and process personal data. So, if there is any infraction stated by the laws, the responsible is indirectly as a consequence of this special system of regulation of the profession. The difference from other workers, the registers in their work, if they make any mistake and there is a loss coming from a third party, this register responds directly with his own property. What I mean is they do not respond. The state does not respond. The ministry does not respond. The register themselves are direct responsible. That gives you the idea, the big responsibility and the need of powerful information that the registers have in order to fulfill their mission the best way they can. And second of all, I would like to highlight something. In these two articles of law that I have just presented, we see the intervention of the register. We have to consider this as well, considering the automation of database, direct access to database. The legislation, the way it is in Spain, first of all, the publicity you cannot get automatically, although there are some mechanisms active that you can use the internet to request publicity, but this request will get to a register that will assess to see if that is a legitimate request and if they can provide this publicity. And also it prevents that direct access, also authorities or other public workers of different agents to access directly this database, because the responsible for this treatment is solely the register that is in charge of those data. And finally, I would like to say this database, according to the public worker that registered this data is public, that in the end of the day is in the DOJ Spain, the Ministry of Justice. So this is my brief introduction. I will refer now to the 2 points of intervention that the register has, and also I'll bring some practical problems that we can face every day. First of all, as the first part of the day, we have to expedite the publicity. The first function is to qualify the interest for this request. We are going to detail. Second, if the qualification is positive, the expedition of the publicity goes ahead, and we see the conditions that this publicity is going out, what kind of information is going to be sent. First, the qualification, it is necessary that the interest of the person that is applying for information fulfills these 4 requirements. The interest must be known, legitimate interest, direct interest, or property interest. The register, many people can apply for information claiming different interests, and also just interest. There is some interest, always the person that applies for information, but not all the interest can go and give publicity. The interest by the applicant has to fulfill 4 requirements, and I will explain them now, deep dive. First of all, it has to be a non-interest. What does it mean? The person, the applicant that would like to see this information must expressly manifest the reason of this application. You cannot stay mute. You cannot say that is a privacy matter. No, you cannot claim that. You have to express the reason for your application. And this reason has to be connected to the person, respecting the use, that it can be done before the information in this registration. So if you lie for your application and then it's a fraud, the information in the registration, you can suffer sanctions because you has claimed a false reason. So that's the interest, has to be expressed and has to be justified and accredited. It must have a finality, and I will detail it more. According to the legislation, the Mortgage Act estimates an extension on the employees or public authorities, always when these public authorities are working. So it's okay. You have to specify if a judge or an inspector access the registration, applying for information, not because of they are judge or inspector, they are going to have free access. They have to accredit. They have been working in an official procedure directly related to their job position. Otherwise, is if they were a private person, an individual. So they must fulfill this requirement in order to access this information. So as I said, this sectorial legislation is very intense and very thorough in this aspect. So, for example, in the articles of the mortgage law says that the registration is public if they have a non-interest. So you cannot say nothing, you have to express your interest. And then this interest is the public authorities that work according to their office. Next article that we have an example emphasizes as well the interest and manifest interest. In addition to that, there is a quote that is in the view of the register. This interest must be known. So in asserting the status of the real property or rights, the interest shall be presumed in any authority, employee, or public official acting by the reason of this office or position. And final example of a non-interest, 2022, the mortgage law. This is about the models and the means, let's call it this way. So you can request information in the Registry of Land. There are two means. You can request directly the registration or also on the internet using a platform of the register's platform. So in any point, you can request information to register. For one side, it's clear in order to apply for information, you have to fill in a form, piece of paper. You have to go in person, or also you fill in the fields on the internet. These two models, they need a box, a specific box. So you give your reason for your application for that data. And what is your interest? That is different reasons, because there are some normal reasons. For example, legal, economical investigation about the solvency of a certain person, legal investigation about the landowner, legal investigation to hire a certain person, or the position of judicial proceedings. So if they do not answer in this, in a previous character, you always have to fill in in your own words, of the applicant words, claiming your interest. As I said in the beginning, whenever I apply expressly my desire, this person is connected for all the future actions to this interest and for their application. And finally, another article establishing this, we can see 227. And again, I will emphasize the qualification of the register to their view. And one more, it has to be a non-interest. The second requirement, as I mentioned, it must be a legitimate interest. What I mean is the finality for the application of this information, it's a licit, a legal interest. It's not just manifest an interest when this interest is illegal, illicit. I want to know what kind of properties a certain person has, to know if they have too many or too little, because I want to kidnap this person and ask for handsome money. This happens. This finality has always to be licit, legal, according to the legal procedures and the objective of that land property. Another example, 2022, Article 7, you have to request the information for licit objectives from the applicant. And this is, again, the emphasis is in the legality of this application that the interested person is giving. These two other examples in this article 2022, the qualification on the register, so is in their view to provide the information according to the application. And finally, in this legislation, establishing that the legitimate interest must be there. So we have different references, these two first requirements, according to the interest, that it must be legitimate. The third requirement that the person has to fulfill, the applicant, is the information, it has to be an interest, a direct interest. The information must be requested for something concrete and direct that you are going to realize. A contract or mortgage, could be a legal proceeding. It must be direct, and in addition to that, to be directly related to the person who is requesting the information, the applicant. So I cannot request registration in Spain information for someone else, a third party, that I can invent. It's expressed and licit. In case that the person requesting this information, the applicant, has to identify themselves in the office, as the applicant may be on the internet, the person has to identify them perfectly, who is applying for that information. In case, as I said, that the person is not directly the applicant, the person interested in this information that has someone else representing them, it have to be credited. So if you work on behalf of a representative, this representative must have the power of attorney to represent you, a contract. So he were hired to represent this person and to accredit that application. But to make things faster in the legal system and not to be so bureaucratic, there is, according to the legislation, a supposition in favor of some people. What kind of people are there? In addition to the ones that I saw before, public workers, authorities who work because of their office, there is also this provision for some professionals whose office is directly related to the property. For example, attorneys, power of attorney, or the real estate agents. But we have to remember also, as a consequence of this disposition on their favor, they have higher responsibilities. They are accountable to this personal data that they are going to give. They are going to receive from that property. I give you higher facilities, but on the other hand, you are accountable for the processing of this data and this publicity that you received on this property. For example, I have some examples here. The Act in the Article 332. These are these cases when the applicant of the information is not the direct person interested, so he is representing someone else. So we'll have to credit in accordance to the registration, to be qualified in order to be an applicant, to see if this application
como el representado, tanto suficientemente identificado.
Or for the representative, if they are identified in order to prevent anonymity or hidden reasons, and also they have to claim by the representative, it has to be in accordance with the use of the registration that has to be related of the licit event, a legitimate interest. It has to be fulfilled here as well. And the fourth requirement that we see as the interest of the applicant, it has to be a property interest. What I mean is, there are two different interpretations here. First, the objective is for property use, and the knowledge is relevant, so they require this information. So I would like to buy a house, and I know who is the real landowner, so I can write a contract. So the second interpretation that we can see for the property, you cannot go to the land register to request specifically personal data of that landowner. As we saw in the beginning, the register is a very powerful database with so much data, property data, real estate, but also personal data is there as well. Maybe it's non-interest for some people that are confidential, sensitive data that has to be very well protected, and publicity is not the main objective for this. So if for any reason, very exceptional reason, they request personal data, the register must be so aware and be extremely careful to see if it's met or not, this requirement. Most of the times, we deny this application because the request has to be a property interest that is the final objective in that registry. We have some legislation and some examples, as we have in the sectorial legislation, that states very extensively all this topic in this Article 227. The interest that is claimed must be known, and check the real estate, who is the owner, what kind of charges they have, if there is a limitation. Also, we need to know if the owner of this property is married, divorced, if things like this or things like that. The objective is always land. That's the Article 322. The objective has to be in accordance of the land register. No, it cannot be on personal matters because all this personal data is protected. So once qualified, the interest, if the register considers that the applicant fulfills those 4 requirements that I previously presented. So we start up the second phase of the work when we expedite the publicity. So I am in accordance with this application. Now I'm going to move forward with this publicity. Why? How can I expedite that? You have to fulfill these 3 fundamental requirements. First, it has to do what I said about the proportionality that we have on data. The publicity in the registration has to be adjusted to that requirement. Second, also connected to the professional processing of the data that are under the protection of the officer, the content must be controlled, what must be included, what must be excluded. As a consequence of the application of data protection, exclude those personal data that are not relevant, first, according to that application, and also the objective of the register, because we see we have to put some personal data, but exceptional character. We are going to see later on. First of all, about the requirement must be adjusted. The publicity that is expired in the registration is according to the application. It has to be enough to satisfy the interest of the applicant, but without extending to more data nor more aspects further than what is being applied for. So this Article 230 says that they cannot refer in this publicity more circumstances than that it was requested. And the Mortgage Act, the same, a simple note, that is the normal way that we give publicity, cannot be extended more than necessary to fulfill the legitimate interest of the applicant. If you say, if the information that you require was one use, and I'm expiring publicity to fulfill your interest, you cannot require additional information because you have to adjust the interest of your first requirement. So the register have performed the qualification, so is expiring the publicity in a simple note. You cannot go further than this. Second, the content control, a simple note, is the basic expression of publicity of a registration and the most frequent, at least in Spain. There are 4 points. First, of course, identification of the land, the description of this property, the location, the city, the town, the size, basic data of that property, that is description of the property. Second, is necessary to identify the owner of that property and have their rights on this land. If there is a mortgage, we must know what kind of mortgage, Banco Santander, Bankia. If there is an attachable good, we need to know what was the court that has sentenced this, the attachable good, the extension, the nature, and the limitations, and if there is mortgage or attachable goods in any amounts for that property. And finally, restrictions and prohibitions that affect the owner and their rights. Am I going extensive? It's very interesting, Mr. Jesus, but I would like to apologize. But we need you to conclude because Dr. Tasso has to leave the session. We can continue later. Perfect, wonderful. Okay, I can go later. Would you like to conclude your idea in point number 2? In the end, I can continue. I was not controlling my time. I'm so sorry. It's okay. Thank you so much, sir.
Right, friends. Unfortunately, we have to interrupt Mr. Quest and presentation. We had Dr. Tasso has to leave at 11, so we're going to resume it afterwards, and he will be able to conclude his final slides. And now I'd like to call the floor to Dr. Anna BERLEE, who's going to bring the reality of Holland and England and Germany. Welcome, Dr. Anna. Thank you for your participation.
Thank you very much for allowing me to speak today and for this wonderful presentation or gathering of experts in the area. And so far, I'm enjoying it a lot. So thank you very much. So today I would like to basically continue or really look at the underlying ideas that we have seen that the previous two presentations have looked at. And I would like to start with, again, reiterating Article 17 of the Brazilian real estate law, and its English translation here, which you can see relies entirely on the publicity principle and is a very open system to begin with. And this is not a very remarkable view. It's not a very singular view. This is what we see in many different states around the world. And I have looked at 3 of those. Particularly in Europe, in my dissertation, which results in this book. And I've looked at the system of the Netherlands, Germany, and England and Wales. And specifically, I've looked at what the publicity principle entails of property law, how it relates to land registration systems, or how it is provided in practice. And secondly, I've looked at privacy, so the right to privacy or the legal right to privacy and the legal right to data protection, and how the two of them mix, if you will, or at least how access to personal data in land registries is governed in these 3 systems, and how the two, publicity and privacy, are reconciled. So if we look at the Brazilian example, again, the very open nature of the Brazilian system finds its match in, for example, the England and Wales system, which has a similarly open system these days, which allows anyone to make or inspect, or so to look at, or to make copies of any part of the register of title. Although, as you can see, the second paragraph of this section provides for exceptions to this right, and I'll come to those in a bit. Another example, which is almost exactly the same, is the Netherlands, which also has a very open system, which says that basically the registrar has to provide access to the land registry and any part of it upon request without asking for the reasons. Now, if we look at publicity, let's look at publicity in theory a tiny bit, which I did in my dissertation as well. And when I looked at publicity, the publicity principle, I found that it is, of course, tied to the third-party effect that property rights have, and is very much related to legal certainty in land registration. And the third-party effect is important because, as well, I don't need to tell all of you, but seeing that property rights have effect against third parties, in return, these third parties should be able to get the information regarding the existence and the content of these rights. And this is what we can then look at as transactional relevant information. So, for example, I do not need to know where you specifically live, and if you are the owner or a renter, and what you paid for your house, if there are any burdens on the house. I do not need to know all of this. I only need to know this if I enter into a transaction with you that requires this information. And this is what the publicity principle entails. It doesn't entail a free-for-all in terms of the information provided regarding land ownership. It has to be transactionally relevant. So if you are a bank and you require information about the person who says that they own this specific property, if you are a neighbor and you want to know if you can walk over the land, for example, then this requires specific information regarding the land and land ownership, but not necessarily all of the information regarding land ownership or any burdens regarding the property. So transactional relevant information. Now, how does this provide us in practice? So publicity in practice, then of course, is by virtue of land registries. And the three systems I looked at all have a very high level of publicity in terms of, or a high level of attaining publicity. Not necessarily meaning that they're very open, but rather they very strictly adhere to this publicity principle and provide the means to attain this publicity. They also, and this is interesting to note, have an information monopoly. So this information monopoly used to be, if you look at the development of land registries, they weren't present since the dawn of time, but we initially saw, for example, in England and Wales, but also in France, for example, we saw that initially the information monopoly regarding land ownership was held fervently in the hands of solicitors or notaries. They were the ones who knew who was the owner, which particular burdens were on this particular plot of land, not necessarily the land registries, which were often very fragmented if they existed at all. Later on, specifically, so there was a lot of, and this is interesting to note, there was a lot of resistance as well to centralized information storage by virtue of land registries, because this required that the information monopoly that notaries had to be given up. Particularly relevant, you saw this in France, for example, where many of the laws that were, or at least were tried to be implemented regarding the publicity principle, were held back a lot by lobbying from notaries and solicitors. Now, as we all know, in the end, the lobby didn't work out, and we do have land registries who now provide all of this information. Now, if we look at the specific legal developments in practice from these three systems, we see something very interesting as well. So England and Wales used to be a very, very closed system. So it only allowed access for those situations where someone could offer a legal right, or had a legal right to access to the information in the land registry. But we saw that slowly but surely over the course of 3 decades, many exceptions to this rule were made by virtue of law. So extensions were made. And then a tipping point came around the late 80s, where the discussion became, we have so many exceptions, when do the exceptions not mean that we have to change the starting point? And they went from a closed system to a very open system. So that was very interesting to note. They immediately discovered that they went a bit too open and they had no safeguards whatsoever, or at least not enough. So in the years subsequent to this opening up of the system, they added some safeguards back into the law and made sure that it became an open system with safeguards. The Netherlands, the development in the Netherlands is very interesting because it was open from the get-go. And the importance of this became, especially the role of the land registry as a information monopoly, or a place where you could get the information, became all the more prevalent when they were required to, or no longer were financed entirely by the ministry, but had to sort of make sure that they paid their own way in part. So the role of this information monopoly and the interest, or the value of the data became all the more prevalent. Nevertheless, shortly after the publication of my dissertation, and I do not intend to say that my dissertation was the reason for this, not at all. I consider it a happy coincidence. But in the same year, a law was introduced to finally provide some safeguards to the very open system that the Netherlands has. So now we still have a very open system, but with limited safeguards. Germany, on the other hand, is also very interesting, the development there, because they had a legitimate interest test, which the previous speaker talked about already, so you know what it entails. So they only provide limited interest, very similar to what Spain has, but they introduced this in 1900s, which is interesting because this was well prior to any type of privacy or data protection even existed as a legal right. And they haven't changed. They have 100 years of jurisprudence on when you have a legitimate interest and when you do not, which was very interesting to study. Okay. Let's continue. Now, the land registry's developments are entirely practical as well. So they have a very practical aspect to it, which is very important to note, because the issue of privacy and data protection, even though you could argue it existed always, it never has been this prevalent. And this has to do with the availability of information, which also previous speakers touched upon. It used to be that if you wanted to know the entire content of someone's patrimony in land, so what they had or how much they had in land, you would have to go through all of the different land registries within a particular country, then have to spend a lot of time and a lot of money on getting the information. Whereas these days, you simply go to landregistry.gov.uk or you go to thecadastre.nl and you get the information, the same information, in only 2 minutes or less. This is what created this issue, or at least made it all the more prevalent that we should at least think about privacy and data protection a bit more. The advantages of, or at least more of these technical, oh, nee, sorry, these more technical aspects, they also had a very practical, my apologies, practical aspect, namely the availability of information, which I discussed, but also the way in which the information is made available by way of computer and in machine readable form as well. And this also means that they can be interoperable. So now we're discussing on a European level whether, and we have made some strides already to make the different land registries accessible from all the different countries. And of course, the very important aspect that information stored 100 years ago on paper takes up a lot of room, very physical room, whereas information stored these days takes up no room whatsoever. So we don't need to think about what we keep or what we store. We can store virtually anything these days. And this is important to know because it means that the publicity principle envisioned in the 1700s, 1800s, or 1900s is entirely different from what publicity should mean or can mean or entails in 2021. So this provides us with an issue of privacy and data protection. Now, the development of the privacy or of the right to privacy really particularly took flight in the 1950s with the ECHR, for Europe at least, which has a specific fundamental right to privacy. And included in this fundamental right is the protection of the home address since 2012, or not since 2012, but the court made it clear in 2012 in the I.C.A.I case that someone's home address is also part of this particular Article 8 right to privacy. And as of course you perhaps know, the ECHR is a living instrument, which means that it isn't very strictly, or it's still strictly interpreted, but it goes with the time, if you will, which means that over the course of the decades since the 50s, we've seen that Article 8 not only regards the right to private and family life and home and correspondence, but also data protection is a part of this. We have many different cases of the ECHR or the court that discuss data protection. Next to this, and perhaps more important in our context, is Article 8 of the EU Charter of Fundamental Rights. Now, with the Treaty of Lisbon, this became a fundamental or a part of the EU legal order, which has a specific right next to, so it's a separate autonomous right next to the right to privacy, which concerns the protection of someone's personal data. And it means that everyone has the right to the protection of their personal data concerning them, which has been implemented or further given weight and specifics in the General Data Protection Regulation. Now, what does this entail? It provides, so the fundamental right provides that your data must be processed fairly. And of course, as our first speaker already noted, Article 5 of the GDPR lists an entire bunch of principles, which entails, or at least gives some footing to this particular Article 8 of the EU Charter. And the third one, of course, concerns data minimization. So the personal data processed must be adequate, relevant, and limited to what is necessary for the purposes for which they are processed. Now, of course, there has to be a legitimate basis laid down by law. This is not a problem for land registries. But the processing has to be for a specified purpose. Now, this is where it's interesting. This particular purpose limitation is in Article 5, paragraph 1 under B, the purpose limitation which requires that the information collected and further processed has to be for specified, explicit and legitimate purposes. And the further processing is only in the matter which is compatible with those purposes for which it was collected. Now, to tie all of this together, we seem to have two seemingly competing interests that don't match. On the one hand, we have the publicity principle, which requires openness and access to information freely, or not freely, not necessarily not by paying, but at least accessible. On the other hand, we have the right to privacy or data protection, which requires a seemingly limited way of processing information, so not made available to everyone at all times. So the question then becomes, are these two incompatible? I have argued in my book that they are in fact compatible when your access right or regime is restricted to what exactly is required based on the publicity principle. So a general open rule of saying everyone should get access at any given time for no particular reason would be incompatible, I argued. In return, you would say a compatible version of these two would be access to the land registry, which is only given provided that it is required based on the publicity principle or any other specific purpose laid down in the law. Now, if we then look at the access in these three particular legal systems, we can make a sort of a rough comparison between the three. Now, the general characterization of these three systems is as follows. The Netherlands, I would argue, is a very open system. England and Wales as well. Anyone can get access for a limited fee. Germany, on the other hand, similarly to what Spain does, adheres to a legitimate interest test before access is granted, which therefore doesn't make it an open system, but rather a limited system. Now, this is important because can you search by property? And this is true for all the three systems, which of course makes absolute total sense in relation to the publicity principle, which concerns land. What about if you can search by name? In the Netherlands, you can. There is one little obstacle in your way, but it's a minor one. In England and Wales, this is limited. Here too, in England and Wales, you have to, while the register title is open, if you want to search the index by proprietors' names, then you would have to convince the land registrar that this information is necessary for you. So they adhere to a sort of a legitimate interest type of test. It's not entirely the same, but it's similar. Germany, the same holds true. It's very limited. You have to have, if you want to search by name, you have to have a legitimate interest to search by name. Now, do you have access to the registration itself? Yes, and yes for England and Wales and the Netherlands. And again, only if you have a legitimate interest in Germany. Can you access it by virtue of the internet? Again, yes and yes via Netherlands and England and Wales. And Germany only very limitedly, depends on the specific land registry itself. And this is important. Do you have access to the underlying documents, by which I mean the deeds? Can you request the deeds underlying the registration information? In the Netherlands, yes, you can. For only €3, you can request the actual deed that was signed by the parties and notarized. And you get the entire deed, not a part of it, the entire deed by PDF. In England and Wales, again, this is limited, and in Germany as well. again, only if you can show a legitimate interest. This is important. Can you, in an individual case, shield your information? In the Netherlands, you can since 2018/19, but only in very specific circumstances. So basically, if you are under threat and you're stalked, for example, you have a court order that someone else is stalking you and they have been told to stay away, a restraining order, for example, or if you're on a protected list of protected persons list, for example, high profile politicians who we do not want the world to know where they live, for example, then you have a possibility to shield your information. But this is not for you and I. There has to be a very specific, very grave circumstance for this. So it is possible to shield some information, but only very limitedly. In England and Wales, you have the opportunity for exempt information documents. So this is the second part of the section I showed you earlier. In England and Wales, there are specific rules for specific cases in which you can say this particular document or this information in the document itself. So, for example, where I live or how much I paid for it, or the specific burdens relating to this would cause me grave harm if these were given out. And then in that particular instance, you can shield this information. In Germany, you can't, but you don't necessarily have to, because we have the legitimate interest test, which in and of itself already provides such a shield. Now, also interesting to note in this regard is how quick are these particular systems. Now, the Netherlands is instantaneously. You get the information either directly or within a few minutes via email. Only if you have more difficult questions of how to search this particular information, then it would take some time. The same is true for England and Wales, and in Germany it depends. You and I, if we go through the regular system, it takes some time because, of course, we have to have a land registrar which assesses our legitimate interest. Notaries are presumed to have a legitimate interest, so therefore they get instant access to the information. There's a particular element of the German system which I haven't mentioned just yet, but their access regime now also allows that you and I, for private interests, go via the notary, which means that there is no longer the specific check by the land registrars. So notaries then can make use of their presumption of a legitimate interest. They will then have to assess on their own if such a legitimate interest exists for this person that asks information, which I have argued is I've critically looked upon this access route because it goes contrary to the idea of basically what our previous speaker told, the importance of the land registrar in this case to assess, and the land registries in Germany are part of the judiciary, to assess whether such a legitimate interest exists or not. And it transfers this power to a notary, and I'm not necessarily in favor of this. Now, interesting to note, so as you can see, there's variations, which means that even open systems such as England and Wales and even the Netherlands don't necessarily mean that no safeguards for data protection purposes can be made. For example, you can limit the search by name. You can limit the access to the underlying documents. You can limit the access to the information that is specifically requested and not provide all of the information at once. So not I only want to know who lives here, and then not provide also all the details regarding how much they paid for it, whether it's mortgage, yes or no, etc. And you can provide for possibilities to shield information in specific circumstances. You can also provide for access logs, for example. So Germany has an access log. You can check as the property owner who gets access, who has been provided access to the information regarding your specific registration. Now, and a final one I would like to discuss, because I heard this was also an issue in Brazil, is whether or not you can get access in bulk. And it's important to note that bulk access basically means you get one spreadsheet with a whole lot of information on several hundreds or thousand properties, whereas frequent access is different from frequent access, which is basically asking hundreds or thousands of times for one single document. Now, in the Netherlands, we also have a permanent connection, which, for example, municipalities have, which is basically a direct connection to the database, and they can access the database independently from the land registry, which basically means the same as frequent access. So bulk access, even in the Netherlands, apologies, bulk access isn't allowed in the Netherlands, or no, it isn't. It simply isn't allowed just yet. There has to be a specific law that mandates that for this particular instance, it's allowed. Generally, you are not allowed to have bulk access to the information. Why? Because even in the Netherlands, the implementation, so the Netherlands is very open, but in the implementation of this rule, the very open nature of the land registry, the legislator told us or mentioned this particular part, and they made a specific rule regarding bulk access, saying the open nature of the land registry does not necessarily also mean that it should be copied freely and bulk access should be granted. This is a very different aspect. It's not tied at all to what is required or why we have a land registry, and therefore access to bulk is very limited. Now, what does this tell us? Now, some brief conclusions due to the time. We see that we've seen that initially, of course, as I mentioned earlier, the publicity principle as a fundamental point or starting point for land registries has long been the only guidance for land registries on what information should be made available. So technological developments were all used in relation to this publicity principle. Only from the 60s, 70s, and really since the Data Protection Directive from 1995, in Europe at least, the different countries started to think, what do we do with privacy and how do these two relate? And more and more we see this advent of privacy rights and data protection rights and safeguards required. And rather than, as our first speaker rightly noted, the GDPR requires privacy by design. Of course, we can't do this anymore for land registries. The design phase has since been passed. But what we can do is implement most of the safeguards, because the GDPR in and of itself does not prohibit public registries, not at all. It even makes specific rules regarding that you can't, for example, have a right to be forgotten in a public land registry, or not necessarily land registry, but a public registry. There can be exceptions for this right that you have as a data subject. But the GDPR specifically and the prior Data Protection Directive do mandate that you provide safeguards in relation to this land registry, for example. So you can't argue, even though the starting point is you can have a public registry, doesn't necessarily come with the same conclusion that you do not need any safeguards. You do. You are required to have safeguards. My perfect land registry would have a legitimate interest test, because this provides the best way, and it adheres to both privacy and publicity. But even if you don't, you can add safeguards such as an access log, such as thinking about whether or not you should allow bulk access, thinking about whether or not you should allow access to the entire document or only the specific parts requested. Thinking about how long you're going to provide all of this information, or if after some time, maybe only a specific element of this. So fragmented access rights, for example, for the external parties. Now, this is just some conclusions, but the main conclusion is the mere fact that the GDPR allows, in principle, a public registry does not entail that it has to be entirely open and that no safeguards can or should be taken. I thank you very much for your attention.
Parabéns, doutora Ana BERLEE, pela excelente
Thank you, Dr. Anna, for excellent presentation. We had 3 great presentations today. It's a very productive meeting for us, makes us think a lot about the subject. I'd like now to call Dr. Tasso immediately. So he's going to do his provocation, his debate, and then we'll follow by Dr. Marcelo Rodrigues. Dr. Tasso, thank you for your attention, for your presence. You have the floor. Hello, everyone. I would like to say, first of all, it's an honor and a pleasure to participate of this event promoted by IBRADIM. And on behalf of Bernardo, I'd like to thank every speakers for the clear presentations. I can say that I have a lot of knowledge that I take from these presentations before even asking the questions that I have here. Professor Madalena, Professor Jesus made it really clear that access is filtered by the primary purpose of the registries, while Anna made it clear that the Dutch openness and right to access, considering the safeguards, interoperability, it's important to bring the learnings that is bulk access is restricted and does not affect the openness of the system. So this will inspire the Brazilian model for sure. In terms of governance, which is what relates to me, different from the reports from the speakers, which the registrars are public. Here it's inspected by the judiciary power, by the controllers of the courts of law. We have 27 in Brazil, and by the national controller, which in terms of data protection, considering the transversality of all aspects of legal relations with legal natural persons, was now regulated by the ANPD. It's the maximum agency, has a directorship and a national council regarding data protection, and they propose public policies and debate the subject. And it's composed by 25 members, 5 from the legislative powers, 14 from the civil society, and only 1 person from the National Council of Justice. So the judiciary power, which has one of the powers of the state to manage 77 million processes, and a lot of judges and public servants, inspects many notary publics distributed in more than 500 Brazilian municipalities, is represented by only 1 of the 23 members. Of these 5 members of the NPD. So in the data production regulatory scenario, the judiciary power has little representativeness, and we have 122 people registered for this 13 positions at the council. So we cheer for these applicants. So regarding the activity, there must be some interaction between the national interactor, the national controller, and the courts of law. Therefore, my question is, does this work group, which I take part of, we've been trying to, with the representation of class associations and several specialties registered, to have a responsive regulation based on Iris and John Blake, to avoid the regulatory overlap and to overcome the capture idea. In this sense, the idea is that the speakers should share with us, based on their experience of their own countries, their impressions about the best way to establish a division of roles between the several regulatory agents in our system, in our Brazilian system. Remember that we have the NAPD, the national controller, and the local controllers. So it's the subject and the underlying question is, could we solve this case by case, so casualism, or by means of the interaction between these regulatory agencies, by defining pre-established fields of action of each of them. I'd like to thank again the invitation. I'm really honored by it, and the judiciary power of the state of São Paulo. Thank you for the invitation. Congratulations to all. Thank you, Dr. Tasso, for your attendance and for your brilliant provocation, your discussion. I'd like to now call Dr. Eva Jacopetti to do his considerations. Thank you. It's an honor to be part of this event. I can say that I've been admiring the quality and the depth of the subject. If I'm studying this subject now, and this has brought a lot to me. I didn't know Dr. Ana BERLEE as a JUÉS. I'm just meeting him now, but I'm feeling very enriched by the quality of all the presentations. And this adds a lot to our debate here in Brazil, because we have our situation here. It's a little bit peculiar, because if one hand, due to the Gdpr, we homogenized the legislation. A lot happened in Spain. In Spain, they had a paradigm of some restrictions before the law, and other countries that were the object of study of Dr. Ana BERLEE. We see some variation, but even the Netherlands, they had adapted to this new reality with the safeguards. In Brazil, we have registry law that is from 1970, and it goes back to previous law. And this aspect of publicity, if we consider this historically, not with the same words, but with the same essence, we go to the registry regulation from 1864, and we couldn't even imagine some type of search that could go to result into personal data. The physical access to registries was very difficult at the time. On the other hand, we have the valid LGPD, which is the Brazilian GDPR, which includes public registries, not disciplines the interaction between them, and must be some way applied. And for now, this effort has been done by the doctrine and by regulatory norms that have been elaborated and debated in the scope of the judiciary powers. So we don't have specific legal provisions that harmonize our law, and with this new reality, these new paradigms that we have of the general data protection law, there are some concepts that we are not explored enough, are not known enough, and this implies on how we understand personal data protection. So anyone can ask for a document, and so what is in this document? What can be certified? Is this a registry? Is this a situation that includes more than one registry, so I can certify the fact that it's not restricted to a specific registry or several registries? And for example, when you talk about a certification that this person has no property, this is a fact that encompasses something that is much bigger. And our law also talks about the provision of other information requested, and doesn't say anything about the person, but parties. But it's also something that is polemic and hasn't been exploited sufficiently. What is this information? Who are these parties? I mean, if I'm talking about any person as a party, we need to understand that the legal processing is different. But what is this information? Information on specific registries or more encompassing information? And that's the point. Can I request documents or information that is a, more like an overview of the registries? Can I request information? How many transactions of a specific nature by single women have been done in the period? It just is just an example, but to try to understand what I'm trying to say here, which is not object of a specific registry, but a bulk registries. This is the first point. In addition, I think that we're here in Brazil, we're due to our history and the adoption of the new GPD, excuse me, if there's a conflict, but we need to harmonize what we already have with the new LGDP, and we have to. We're going to an open system with safeguards, which is similar to what we have in the Netherlands. And the paradigm in Brazil so far, in practice, is the more information, the better. But we need to restrict the information we collect, we store, and we file, and the information we transmit. If I can have more information. And the new paradigm is no, we need less information, and so on. So I'd like specifically Dr. BERLEE to go a little bit deeper on the subject. What are these new safeguards that have been adopted in the Netherlands, and how this implied in some changes on the previous scenario, and especially regarding the bulk requests? I think there is very clearly, except for exceptional situations, an intent for search for data. I mean, if they can, someone can buy 100 properties and ask for the documents for this property, but in general, if someone does this type of search, they want to find some other information other than the legal situation of the property. That's what I had to say. Thank you for being able to participate. Thank you for the invite. Thank you, Dr. Ivan. Excellent ponderations. Dr. Marcelo Rodrigues, Chief Judge. Yeah, we also would like to say we're honored to have your presence here. Thank you so much. I'd like to first congratulate Dr. Madalena, Dr. Ana BERLEE, and Dr. Jesus Alvarez. They brought us master classes about the incidents of the data protection law in different systems with different register publicity situations. I'd like to start my participation in the condition as in the ability of debater to request a reflection. I see that in general, as an area of knowledge by excellence, law has not incorporated more advanced methodologies to model complex systems. There's evidence on the perception of society and inhibiting the practice that transcends the discipline. So in fact, we have observed different examples of laws and decrees. In the other hand of the evidence and the legal mechanisms are related to the provision and behavior and cognitive science is the point of meeting of neurosciences, mathematics, and psychology, linguistics, psychiatry, and computer sciences. So above all, it's an area marked by the receptiveness and interest of complex systems based on information and intelligence. So we note that cognitive sciences is kind of an European block of knowledge, but do we have space for a cognitive revolution in law? Recently, a new area, which is scientific experiment production with neuroscience and modeling, computer modeling, has been applied to solve conflicts between trade dress, unlawful competition, and so on. The trend of knowledge that influences human life has a pendulum movement. It's progressive, so it breaks the wall of hyper specialization. The movement in the other direction recently, a few years, became stronger. The areas that have hyper specialization started to implode, and we realized that it would be interesting to merge this whole fields. Then we have cognitive sciences. It's a noble enterprise, as mentioned by our Dr. Avilo Diaz. The professor of informatic rights in Harvard says that there are some data laws that they are born already and already old. The GDPR is a good starting point because companies started to have to adapt their practices to accommodate the new laws. However, it says we're behind because only now there are some deficiencies from 20 years ago that are now being made right, and they can repercute in next decades. In 2014, Jonathan said that Facebook could define an election without no one realizing that. 4 years after that, this forecast became true, and the scandal of Cambridge Analytica confirmed that personal data of social media manipulated the elections in the United States and the Brexit as well. The technique followed now does not reflect a real choice because most of the sites show a banner on the bottom of the screen saying that it collects cookies and you have to accept or deny this. But how many people really read the terms of use or set their privacy configurations in the website? In fact, these rules should not focus on the choices of the users because it's difficult to have a conscious choice when you enter online just to check something quickly. The concept of anonymous data must be regulated because they're essential in several areas of artificial intelligence and big data. These are data that can be sold in the market or even required in case of governments. And they are used by many technology companies, either for good or for bad. Currently, we have the Brazilian General Data Protection Law, and Brazil is considered one of the countries that has adequate protection of data and information. However, there are some data that our law is not protecting. And the Netflix movie, The Social Network Dilemma, put a perspective on the deep social impact of the directioning of the content and the profiles of social media users by means of massive collection and processing of personal data, which is a practice that is reasonably immune to the data protection here in Brazil and also in Europe. We realize that we're not completely protected against inferential analysis of new technologies. The laws, it's difficult for them to regulate how and by means of which parameters that data is assessed. We see that the European regulation ensures that review of automated decision must be in charge of a, like, quote unquote human, but the Brazilian law mentions only vaguely the right to review. So it's important to say that the decision of an algorithm can, in thesis, be reviewed by another algorithm. So how can we prevent unlawful or unfair decisions based on the behavioral profiles? Well, the guarantee of right for privacy is one of the biggest goals of the data protection laws, to allow more protection on for people about their data by means of transparent and safe manners. to ensure the fundamental principles and rights. Also promotes economic development in a society developed by data by means of clear rules on collection, storage, processing, and sharing of personal data by companies and by the public power. This reduces costs, it strengthens the trust of the society in the collection of personal data and uses of data. The final result desired is an increased legal safety in the use and processing of personal data. Concluding, for our reflection, in the registry publicity system, in transfer of data that allows identification of the specific owners, the request of information regarding specific information or selective information said transversal should be consider a few premises, such as reduction of risks, even in face of legitimate purpose scenario. So we transfer only what is strictly necessary should be transferred, but some issues remain. Example of the change of name or gender or affiliation or all of this sensitive data initially included in the natural personal civil registry, but how can we check, how can we provide protection to the data owner in the registration of the land that they own? From the general data protection law, the notaries and registrars must prepare the privacy of these parts. The owners of this personal data must know how each notary or each registrar uses their information, their personal information, and how they're being maintained safely. These are my subjects that I would like to propose for discussion. Thank you very much. Thank you, Chief Judge. It's very good to hear your imponent voice, full of wisdom. My dear friends, we're going to our second block in part that the international speakers will provide their answers to the questions proposed. So I'd like to propose the following. To consolidate the questions here, I would like to propose that Anna BERLEE should explain a little bit about the safeguards in the Netherlands, like Dr. Jacopetti said, I think, which is the system that is more similar to the system here in Brazil. Dr. Madalena could answer about the regulatory issue, according to the questioning by Dr. Tasso, and Dr. Juez could end, completing the previous thinking and provocation made by the Chief Judge about the bulk access and minimization and the work of the associations, which in Spain has been determining for the standardization of their data protection laws, and how this worked, and if this can work for the Brazilian paradigm. So, Dr. Anna, I think that the time, it's 15 minutes for each. I believe that's it. Just give me a second to confirm. Yes, 10 minutes each. Excuse me, 12 minutes each for your answers. Okay. Dr. Anna, please, the floor is yours.
Thank you. And thank you, Dr. Jacopetti, if I pronounce it correctly, for your questions. I think there were two separate ones, but they're very much interlinked. So you asked for the specific safeguards that were introduced in the Netherlands, and there's actually two parts to this. So initially, prior to the Data Protection Directive, we had a different legal rules regarding data protection, and in that specific law, public registries were exempt entirely. So public registries did not have to adhere to data protection regulation at all. So when the Data Protection Directive in 1995 had to be transposed into national law, this was the first time that the land registry had to legally deal with the data protection rules that came with the Data Protection Directive. And what the Netherlands did was basically saying, or implement this by specifying the specific purposes for which the data was collected and maybe processed further. But they did this not in a very, how do I say this nicely? They weren't very specific. So the purposes were basically legal certainty, proper way of trade, making sure that trade could function, and making sure that public institutions could function and could collect the information as well. So this not necessarily is specific enough, I would argue, these days. But nevertheless, so they made the specific purposes known. So that was the first safeguard, if you will, or at least they narrowed it. But the more important one was that they introduced these three specific options for limiting the access to the land registry. But this required, so they basically said in the main law, so in the formal law, they said you can have 3 exemptions, or basically 2. So you can have specific rules if this is required for the individual, which they didn't make use of until 2019. So for 9 plus years or 10 plus years, they didn't make use of this law or the ability to enact a law. So this legal basis. And the other was that bulk requests were exempt in the sense of they were not allowed. So they were categorically not allowed unless a specific law was created that would allow such bulk requests. And none has also been made available. Now, the bulk request issue that you oh, sorry, and I'll come back to the bulk request in a second. But what they also did after 2018 is they made use of this option to create specific rules to exempt individuals from this open access regime. So the search by name was limited, or at least if you searched by name, for example, if I was stalked and I had a court order that stated that I was being stalked by this particular person or another, I could go to the land registry, show this court order, and they would then provide a sort of a checkbox after my name. And then anyone who would search on my name would get this information box that said, please go to this and this department and ask for this particular information. And then basically, if it was then a notary, then they would get the information due to the legal certainty that is required. If it's someone who's very interested in the information, they would not. So that was the specific, so they limited the search by name. However, if that particular person would ask for the information regarding the property of the piece of land I currently live on, they would nevertheless get the information with my name included. So it's the limitation only by the search by name, which was the safeguard that they implemented. And they did this in a very restricted way. So basically only those people that got police protection or high profile politicians or high profile judges, for example, they would be able to be shielded from this thing. And it's a temporary shielding that only lasts 5 years. You have to reapply after 5 years. So that was the safeguards that they implemented, which aren't necessarily a lot. But to come back to your part regarding the bulk request, because if I understood you correctly, you said, well, there's also an issue with statistics and how to make statistics. For this, you require bulk access, obviously. And how to relate this to, I think this, for Brazil, this is specifically an issue with the decentralization in Brazil as well. So you don't have a single point of access for all of the information regarding every plot of land in Brazil. You have to go through the different areas, if I understood this correctly. So the issue of getting this bulk access from each of these, I would not necessarily characterize this as a problem, because so in the Netherlands, of course, we also have statistics regarding house prices, example, the development of house prices, and statistical processing. So for statistical purposes, the processing of personal data is considered a purpose which is compatible with the original purpose for which the data was collected. So if your intention, your purpose for the specific processing is to get statistical information, which, if done properly, does not include identifiable information regarding a natural person, obviously, so the result is anonymous data as well, then this transfer may take place, because it is deemed or at least initially, yeah. So you have a legal ground. So the legal ground for this particular processing is perfectly fine. There's a specific rule, Article 989 from the top of my head, which deals with the specific safeguards that statistical processing has to adhere to in the GDPR. But one of the principles, so the purpose limitation principle that Professor Teixeira also referred to, specifically states that a statistical or archiving in the public interest or scientific research are purposes which are deemed compatible with the purpose for which the information was collected. So I do not necessarily see a specific problem, or at least I see options within data protection law to provide information from these specific decentralized land registries for statistical purposes, which of course then also entails that after the statistics are done, you should remove the information. There's no need to keep it any longer. And I believe that answers your questions. If not, I would love to hear.
Excelente, doutora Ana, muito bom, muito bom.
Thanks, Dr. Ana, it was wonderful.
Bem,
Okay, now let's hear again Dr. Madalena. Yes, I think that I have to answer these provocations, not my complex, but this division of tasks that we have to implement, considering the control and significance of compliance with the principles and rules applied in terms of personal data protection, and how things in Portugal work. They're a little bit different because since we're all public officers, we have to follow the structure of the Ministry of Justice. We have a regime of inspection of these activities that doesn't go to the judiciary power. So everything is done internally, and but clearly the Data Protection Commission is the national control agency in terms of personal data protection, and we all have the obligation to comply with this authority, but to ensure compliance of the rules and principles in terms of personal data protection, but also with judicial. We have to situations in which non-compliance can be considered as a crime and would result in prison time. And so all of these entities have to articulate considering how to ensure the compliance with these principles and rules. Regarding personal data protection, I would say that in Brazil, you have to have the same thing. There have to be a division of tasks, a proactive team and collaboration and the entity that is related to registry activities must have a pedagogical attitude to define the policies and the behaviors to ensure information security, and also inspect the compliance of the registrars, because they have to comply with these rules, is to comply with their functional duties. And then the control authority, the national authority, controls and inspects and the compliance with these rules and principles. And the success depends on this proactive attitude of the officers, of the controllership, and it has to be a work that is done by a team. In Brazil, it also matters to find what binds the information security laws, privacy rules, and the success of the national control agency. So must have a more active role. I'm not sure if that is your points that Chief Judge wanted to approach. I think how we're going to organize to ensure compliance, because there are several entities involved at several levels of hierarchy and levels of duty involved. I think maybe we can define a policy that is effective for personal data protection. And I'd like to react a little bit to the provocations of the Chief Judge Marcelo. I'm not sure if the maxim informing less to protect more can be a dogma. I mean, I have some doubts, because we have to, not that the Chief Judge has said that, but let's reflect on this, because I think that providing less information can also have the scope of the land registry. The information must be appropriate, and the appropriate information is in this land registry. So it's a matter of the legal situation of the buildings. So we have to find a balance to allow not sacrificing the function of the registry system. It has its role, and it cannot be restricted because of personal data protection. And in the end, I think we should panic and should not panic and find the right balance. That's it. Thank you very much.
Muito bom, professora Madalena. Muito obrigado.
Thanks, Dr. Madalena. Thank you very much, Dr. JUÉS. I think now we have the final comment about bulk requests for land registries, and that we have the purpose of extracting from this registry bulk information. What is the processing that you've done regarding data protection in Spain? Please comment on the role of the associations in the regulated self-regulation. And last point, the change that we have in terms of minimization of information that is included in the registry.
First of all, about the bulk request, they pass and different objectives. So considering what I said in my explanation, you have to see the objective of this bulk request. If to get too much information, so you can create parallel register to the land register, they have to be limited. The only register that officially has political effects in the property registration That's why we have so much information and there are so many controllings to be safe, that information is safe. So in any case, it's possible at any point in time request partnerships in the register collegiate, decentralize the work of all the register in Spain. I am an investment fund and I want to buy 1,500 pieces of land in Bank Santander in Spain. So you receive a bulk request that are licit, legal, and with the objective is property, and you have to fulfill this request. For example, that happened recently in Madrid. It was requested as well, bulk information about the real estate that a certain bank had, and the objective of this request was to promote a social rent, so these buildings were not invaded, and the final objective is to foster a new rent, preventing the illegal occupation of that building. So the register office is limited to this interest. So the publicity is under the responsibility of the office. You cannot expose a person to the truth of machine if they request a registration. You always need previous information and analyze the reasons for that bulk request. About the work of the register collegiate, it's easier in our work because somehow they centralize the individual work of the registers all over the national territory. And they also work developing certain tools, for example, for data protection, and they also develop programs to be deployed individually in different register centers to fulfill the compliance of the legislation on data protection. And finally, is a meeting point of all the database. Somehow they are shared all over the national territory. Someone can go to this collegiate, and this collegiate will not provide concrete information, but will tell what is the registration that they have to go in order to achieve that information. And finally, about this balance between the publicity that you give and the data protection that you provide, my idea, my opinion is that you provide more publicity, the better, but of course there are limits. So if you want to have a real estate register with legal effects, you have to make easier. First, more importantly, the register is truth with the reality, because there is a disconnection, register and reality, they are useless. So you have to foster people subscribe in their registration. The subscription is voluntary for their land. So if you want to motivate this inscription, you have to give people guarantee they are going to subscribe their registration, and their data, personal data especially, will be processed professionally. So I believe they do it. There is a paradigm, almost this information that is automated with free access, any citizen can get. So you put publicly data that can be very sensitive to certain people, and as a consequence, if you do not subscribe, and as a consequence, the land registration is not as a strong agency as it should be.
Perfeito, doutor JUÉS.
Dr. JUÉS, would like to thank you so much for your comments. I would like to now conclude our event, our seminar, and very quickly I would like to comment the Brazilian scenario in order to let you know what is valid already and what is still being defined in our country. Dear sirs and madams, I would like to thank you thank all of you for the excellent meeting we had at a very high level and an unprecedented event with proposals of confluence of ways of thinking, of reality, and related to Brazilian situation, and contributed significantly to our debate here with three great professionals from abroad and three great professionals from our country here. I would like to thank you very much and congratulations for the high quality of the debates. IBRADIM, yes, our doors are open to our associates. The Institute was created, was founded with the proposal of gathering all professions, all parties that are related to land registry laws, so that we can mature the proposals, exchange experiences, and then have a better level in all regions of the country and different views on the same subject. So before I'm going to talk a little bit about the LGDP here in Brazil, I'd like to show a video that shows IBRADIM and invite you all to
Excelente. Então, o nosso site é o ibradim.com.
Nice. Our website is ibradim.org.br. So you now have the LGDP, which, excuse me, just give me a second. LGPD. We have the LGPD is approved in 2018. 2019, it's already valid. The provision regarding extrajudicial services is in Article 33, Paragraph 4 of the law, which says that registrars should and notaries should follow the same rules of the public administration and to maintain the transparency and therefore their privacy policy in the article provided in Article 23. So they have two realities: the private reality, which must adopt all the catalog of the data flows that we have regarding the private management, which is in Article 28 of the law, and also the public part, which is specifically dealt in Article 23 of the law. What is currently valid, at least for the next years, the beginning of administrative penalties of the LGPD and regarding the division of competences between the controller, the national controller, and the NPD, the agency. We hope to have a clarification between these roles, because since it's a technical agency that deals with extrajudicial issues, the application of the Article 236 of the Constitution, which says that establishes the activities and the inspection of the judiciary power. We have a slide that I'm going to show you very quickly here, and this makes it a little more clear, considering the Brazilian reality. So here we have, if we can talk about the obligation of the notary publics, we talk about contracted obligations, which are provided in the LGPD, elaboration of the privacy policy, catalogation of data flows in the public service. This is already valid, but we need some common implementation because the law is not completely clear. But we also have the effectiveness regarding specific regulations. Some locations have already acted, and now we're talking about the public part of the public registry service, which is, this debate is much more accentuated. For example, as the controllership of the state of São Paulo, they regulated the rule and regulated the obligation of, in case of bulk request, they must request the purpose and possibility of the delegatee approve this or not, and question the purpose of with searches for personal data, as well as Article 15 of the provision of Bahia. I think it's from 2021, very recent. There's also a similar regulation in Amazonas. So finally, we have good practices and specific standardizations, soft law and regulated self-regulation. So Article 55 or 51, if I'm not mistaken, of the LGPD, it's similar to the European model, emphasizes the importation that associations must act together with the complementation of this regulation in practice. And today we had a lot of good practices, and we'll have to regulate Article 50 it will be regulated by the competent authorities. I would like to now thank especially I have too many windows open here, making me go crazy. So I'd like to thank everyone who contributed with our event for its success. Also, I'd like to thank the equipe Flávio, Aliança Traduções, the interpreters, Mateus and Vitor. Without of you, we wouldn't be able to hold this event. I'd like to thank Alexandre and Toledo, who are the president and coordinator of our commission of IBRADIM. We gathered great names from all over Brazil. Also, the council of the institute and the members of the research group of IBRADIM. We will continue with our research, and like to thank very much IRIB on behalf of the President Jordão, who's an enthusiast of our event, and Flaviano Gallardo as well, also a great enthusiast of our event, ENNOR and CNR, on the person of the President, Marcelo and Dr. Fernando. Thank you for all your support. I'd like to thank everyone who's been here in attendance. We'll follow the debates. The IBRADIM, thanks you very much. The Brazilian Society, thank you very much. Thank you very much. A big hug to all.